All right, greetings and welcome to everyone on this March 18th, 2024 Legal Policy Committee meeting. It is 5:53 p.m. and we're going to jump right in. We're getting started a little later than anticipated, but we will still try our hardest to get out on time at 7. So the first item on our agenda is 1.01, previous meeting summary from our recent meeting on February 20th. And if we all have our packet here, I'm going to try to do my best to walk us through this because we have so many. We get a little booklet every single meeting. So the first one on here is our agenda. The second stapled thing is our previous meeting summary. If anybody has any comments, additions, objections, opinions, concerns of any kind. While we're reviewing these, I do have one request for conversation. We do have on the minutes here when we start, and I wonder if we can add that to our agenda somewhere, that we plan to start at 5:30 or we plan to have our meeting 5:30 to 7. I think that would be helpful. And seeing no opinions whatsoever, we can all take the last meeting minutes and set them in a separate pile so we don't confuse them with any of the other documents that we were referring to for the rest of this meeting. So the next item on here is our discussion topics. This is policy 10691, public participation at board meetings. As a review of this policy, this was first brought to the committee in the fall because it started as a Neola update, but every time that we have read into this, we have noticed things, added things, and this is one of the more recent, because last time we had two separate documents. We had the proposed one and our current. So this is a hybridized version of what we have as our current policy, and that kind of inserted into the Neola policy. One of the differences I noticed on our current policy is this 118, which is the next thing. This was referenced in our current policy, which then if you look underneath 118, this one is our current. So for this part of our discussion, to see if we're ready for a first read, we actually do have 3 documents that possibly we'll be referring to. So did you want to add anything?
So the updated policy that you have in front of you has the word committee included, as was discussed at the last meeting. So you'll find now that the second parentheses / bullet on the 2B, hopefully, public participation policy says at all regular, special, and committee meetings, as we discussed. We've also made changes to include D, individuals may not register others to speak. There was some clarification made, if you remember at our last meeting, that Ms. Folk pointed out to make that clearer, and G as well is now selected to say during the portion of the meeting designated for public participation, no participant may speak more than once. And then on the third page, you'll now see J, which is a section that was included as G in the current policy. So J and G in the current policy and J are about the same thing, and they are both about the duties of the presiding officer, basically stating that the presiding officer may deny requests to speak and basically to maintain control of the meeting during public participation sessions.
Are there any comments about these sections?
So my comment is around the time allotted. I guess I'm thinking about special meetings or committee meetings, which tend to generally be shorter in duration. And so I'm wondering, do we need to make an adjustment for those types of meetings when it comes to the public comment? Or should it be 20 minutes as it is for our regular meetings? So that would be under J.
I do see in our current policy, we do have 20 minutes per meeting, so that would count for our special meetings presently. We do have 20 minutes. But now that we are adding committee meetings to this, how do the members of the committee feel about the time allotment for public participation?
So I think about maybe a special board meeting that has a singular topic that we're trying to get to. I mean, we don't want to, I guess, take up half the meeting with comments. I don't know. I'm just asking if it should be the same amount of time, since those meetings tend to be shorter.
So one reference that is in the 2020 policy is policy 118. And we have that in here. And I think this is relevant to your comment also. I was not here in 2020, so I don't know who put together this policy, but it referenced our bylaw of 118, and it was responsibilities of the board. And in reading this, I thought it was a good framework of why we are offering this time. You know, the board declares and hereby reaffirms its intent to, and it looks like this is from 1997, but maintain two-way communications with the citizens of the district, you know, establish policies, make decisions on the basis of declared goals, act as a representative body for citizens. And so with that framework in mind, if there are 20 minutes worth of people, even for a special meeting, do they need to be heard? I think back when I first joined this board and we had, it felt like every single meeting we had, there were, you know, students and families talking about Leggett and Kenmore and Miller South, and they all wanted to be heard. If we get rid of that 20 minutes, are we preventing them from participating?
So I think we still, as a board, could, by a simple majority, vote to extend that, because I think we did that once already. So I guess if there was a need to, we could extend it. But I just wanted to bring it up for consideration, just because those meetings tend to be shorter in nature. I don't know if it makes a difference or not to anybody else.
It doesn't make a difference to me in this. I think as it is, it could be consistent the way that it already is, instead of having to extend something. Because the presider, as I'm understanding, could put a halt to conversations if needs be, correct? In order for business to be conducted. But I think I'm in agreement with Member Molnar that if the people want to speak on a specific thing that's in a committee meeting and give their viewpoints, I think Member Sykes stated this before, that's the time versus when we're in the actual board meeting, and the committee meetings is when it seems like most of the discussion should be happening over issues, since that really can't happen in the board meeting, because it's more participatory, it appears, based off the language and how we wrote it in the committee. So I'm in agreement with it remaining at the time.
Yep, Madam Chair, I would agree with remaining, keeping this time.
Do we feel that we would like to keep the reference of bylaw 118? The reference is in the current policy. The reference is not in the Neola policy because Neola did not know our bylaws. Would we like to keep that reference as a reminder of our framework for communication with citizens of the district?
I'm fine with it, Madam Chair.
All right. So with that, are we able to, just in this first paragraph, add that reference?
Yes.
Thank you. Are there any other comments or feelings on 10691?
No, Madam Chair, I think we have adequately discussed this.
Thank you. Now, in adding that bylaw, I think, so this is presently in Section 2. Section 2 is for our first reading. This particular policy, I think, has had 11 first readings. In adding that, do you believe we should keep it in for one last first reading, or can it move to?
I think because the reference is such a small change that it would be fine with having this be the first reading, unless the members of the board feel otherwise. It's fine if we do it either way, but to get it, off of the agenda and moving forward, I think it would be completely fine to just add the reference and move it.
Are there any objections to this being considered the first reading?
No objection.
All right. Thank you. So with that, policy 10691 can actually move now to section 4.2, policies heading to the board agenda for a second reading. And I feel like celebrating because we have talked about this one for so long. All right, thank you. Next, we will move to section 3.1, discussion of policy 0147, compensation. This is next in your packet. This was brought up in new business during our last policy meeting. And now it's in roundtable, so once we discuss this, at the end of this, I would like the committee to have an opinion on whether or not this is ready to move to stay in discussion or move on to a first read.
Thank you. So this policy is about board compensation and is currently outdated. The issue is the math here. So it's $125 for up to 50 meetings. The problem with that is that that goes beyond the statutory amount, which is $5,000. So it would currently add up to $6,250. And the last time we very briefly discussed this policy, Dr. Molinar suggested that we should add some language that is much cleaner and simpler and that just states up to the statutory amount. I think that would be best, as far as us not having to continually update this and make sure that there's nothing in the future that invalidates the policy.
All right, and And does the committee feel that with that amendment, we are ready to have a first read of this in our next committee meeting?
Yes.
Yes.
Thank you. Moving right along, I'm looking at my calendar just for record's sake. It looks like our next legal committee meeting will be April 15th, Tax Day. We'll have a finance meeting and a legal committee meeting on Tax Day. So on our agenda now, it looks like for under 4.2, we have 10691 public participation, and then now 4.03 we'll have policy 0147 compensation heading to the April 15th legal committee meeting for a first read. Now, to prepare for section 4.4, policies expected for discussion in our next meeting, because we do not have any unfinished business. We're moving on to section 6, new business. So the first thing is clarification of the agenda. There has been some confusion as policies are leaving the committee meeting and heading to the board meeting. What's a first reading? What's a second reading? What's a third reading? I think we had some that were said second and final because we were doing our first readings here in the committee. I had a graphic in our January meeting, but I don't think it made it in here, so I apologize for that. It was my intent. I can bring it back. But in the graphic, we described how policies move from new business all the way through how a bill becomes a law, all the way through. And so as we are having the category here, policies moving to a first read, there will be no surprises. In our next meeting, section 2 is the first read. And then as the policies move to our board meeting, that will say second read. So at our actual board meetings, when we review it, it will not say first read. It will be the first time there, but it will say second read. And so then the second time there, it will be third and final. And so I did try to clarify that in last Monday's meeting, but because when we voted before then, I think 3 times in a row there was confusion. So I wanted to clarify that. So moving on, next, in new business, the racial equity policy. This was something that was in my notes from our board retreat that, actually, I think, Madam President, it might have been you or the Vice President. We were talking about the minority business owners and the policies in place and how that was on the list to expand things. So I didn't know if we wanted to have a presentation on what other districts have versus what we would have as our policy on how we were looking at our expansion of MBEs.
Yeah, I think this is something that, as far as this policy, the presentation can happen in equity committee. That there's been a presentation presented on this topic within the equity committee. So I don't know, as far as maybe, are you saying like having that same presentation be presented again, or maybe just the language of what needs to be done based off of what Dr. Chapman and the others working with the equity committee has come up with, to kind of see how what suggestions they've given in the rationale to improve our working with the different minority businesses in the district and making sure that it's job opportunities and different bids are being presented in an equitable way. Is that?
So the equity committee presented, and that might have been where one of the conversations started, but we did not examine the policy, so I didn't know if it was the desire of the board to examine our policy and compare that to what Columbus, I think they were mentioned,
Yes,
or other districts
yes.
have as their policies.
Yes, I think that would be good. And that was an email I sent. Yes, yeah. So, yes, I think that would be good. Because we're talking about equity, so we want to align our policies to make sure we're, in fact, are doing what we say.
Okay. So is this something that we would want some of the equity team on, or would we want it to be more attorney-centric to bring what the other, for some of the other policies, for instance, they brought us what other districts had. I think that's actually how we started our public policy discussion, is we looked at, 5 other districts and what their policy said, and then how that compared to our current policy.
I think that would be good as a reference point, but I think also it would be good to look at the current policy that we have, right? And how are we aligning ourselves with our actual policy? Because I think that was a lot of the question. We have this policy in place. How are we adhering to the policy we have in place? So I think some comparables, I'll talk with my hands, sorry. I think the comparables with the other district, yes. I think that would be good. But also, yes, as far as with the equity committee that's doing the work, because they're seeing those gray areas within practice, policy and practice. So how can we more align practice with policy within the district?
Okay. So as we move 2260 into our roundtable section, are there any other comments, questions, or concerns around the table? All right. So we will move on. Next new business, it says policy 7544, use of social media.
Madam Chair, President, and members, I'm Mike Deffelbaugh, Director of Labor Relations, and I drafted this policy. One of the things that I realized when I began this job is that there was an absence of social media regulation, and I think it's best practices to do that. And so what this does in a nutshell is it does 3 things. One, it organizes the structure of the social media platforms, and it does this by having the communications director be the clearinghouse for all social media district platforms. So in other words, any schools, anybody who's running them, it'll be under the clearinghouse of the communications director to understand and know what's going on. Number 2, it allows and identifies authorized users. And that's important for a couple reasons. One, you can have somebody who starts a platform at APS, and you need to go ahead and have passwords because someone may leave, or you may just have something sitting there. So that's a second function for the communications director, to be able to be the clearinghouse so we can have some control. It also defines and establishes the rules for authorized users. So you'll have an authorized user, 2 preferably, per social media site. And it tells them, and that's Addendum Exhibit A. I think that's important because it provides guidelines, and the U.S. Supreme Court just ruled on this case last week. This tells you when you can go ahead and block somebody from participation on an APS social media platform, or you can go ahead and mute them, hide them. The Supreme Court just handled that last week, and mercifully, it did not do anything to take away from my Addendum Exhibit A. So I think that'll provide a really nice uniform guideline for when they're participating with the public, because you'll get things posted that aren't too kind, that are mean, vulgar. And so I think the authorized users need to have some understanding of when they can go ahead and block a user. So I think that's a big component for liability. And also, as an overview, what this does, it defines and outlines the prohibited conduct for employees using district-owned social media. what's prohibited, what's permitted. It gives fair notice to the employees. And it does also a third thing. As government employees, even when we're using our own social media accounts, if I identify myself as Director of Labor Relations and I say some improper things or post some improper things, I can still be held culpable. What this policy does is outline when those employees, even using private, your own personal, phone, and you're holding yourself out as a district employee, when you can be disciplined. So that's what this does in a nutshell, those three overarching things. And I'm happy to take any questions you may have. Yes.
So for clarity purposes, this is saying, so if it's a employee of the district that is not pleased with something that happens within the district, and they make a post to that fact, or they're in discussion on their personal Facebook post, that then that post can be screenshot, shared somewhere in HR, and then there's a consequence for that.
Correct. And you would analyze it, obviously, under the First Amendment, looking at matters of public concern versus what they call quintessential beefs, which is, I shouldn't have been disciplined. My supervisor, Mike Defaball, should never have done this and calls me a few choice words. That's when you're getting out of the First Amendment. So that's what this is really trying to do and protect, and it lays out, I think it's fair notice for employees to assist them, but yes, that is exactly one component of this policy. It does that.
Okay.
So thank you for presenting this new business. I have questions for the committee now that we have received new business. Is this an item that we would like to see moved into discussion for our tax day committee meeting? And if this is moved to discussion, what type of information would we want to receive, to have presented? What format would we like? What would we like to know and be prepared for in April? If we so choose to move it forward for discussion.
Yes, Madam Chair, I think that we should move it forward for discussion.
All right, so that is 2 for move. Oh, go ahead. Yep.
Oh, no, because you asked, it was like a two-part question, like, is there any additional? So that's why I was looking through to see what would the discussion, what do we want to see? It looks like you have this pretty much laid out as far as specifics as to what it would cover. And I asked my question to make sure that it wasn't infringing on people's First Amendment rights. And I do understand when you work for an organization, though, it should be some integrity and pride within the organization that's employing you, if you want to remain employed. But I know there's rules and things by that. I just wanted to make sure that still as Americans, that rights are still preserved. And it looks like you covered a lot of that even in your discussion. So at this first quick glance, I don't have anything, but I may have something emailed later. I don't know.
Absolutely.
That I want to ask.
Thank you. So we will move this forward for discussion. Does the committee have any comments or preferences? The 2 documents here are actually very, very thorough, more thorough than I expect for new business. So thank you for that. But at this point, does the committee feel the need for like 5 minutes or 10 minutes idea presentation, or should we have a timeline of when we might email specific questions to have presented in the discussion section? How would the committee like to proceed?
I'm not sure about a presentation personally, because this seems like very detailed. And I think if it's any questions, I don't want to put anyone else on the timeline, but I'm going to look through this and say probably like within the next 48 hours, if I have a question, I could submit it for follow-up within the discussion. And if not, it's not that deep to discuss.
Same here, Madam Chair. I will review. If I have questions, I'll send those to you.
Please do.
So I do have a quick question that can be brought back for the discussion. So does this spell out, because I know you mentioned the communications director being the clearinghouse, and I'm just assuming that at the building levels, though, they still have some autonomy in what they can post specific to their buildings.
Oh, absolutely. When I use the terminology clearinghouse, I'm talking more organizational rather than content. The content, that's the Exhibit A, that's more for what we term our authorized users. If Dr. Robinson made me an authorized user for labor relations, if I wanted a social media site, I would have to comply with the content I'm putting out and how I'm responding to the public. So I'm not just deleting. If somebody said Mike's a terrible lawyer, I can't delete that. I mean, that's not offending the First Amendment or our rules. So that's what the addendum is doing there, is to guide our employees on how to handle, deleting versus not a comment so we don't get sued. But yeah, make no mistake, the communications director will not be regulating content per se. It's more of an organizational realm for the district due to its size.
Thank you.
I am not a huge social media user. I don't know about other board members, but would it be useful at all to have examples for anyone, or is the discussion sufficient? Coming up.
An example of something that would be dinged, is that what, for lack of a better term, an example of something I personally would need an example, but I don't know if having something for the public and employees to see may work. But I would say, I don't think that we need it. That's just, I'm one person. That's just personally, I don't think.
Yeah, maybe an easy example for the authorized users, if somebody's campaigning using our APS, our district owned and operated, and you have somebody out, maybe they're running for judge and they're campaigning Mike for judge. Stuff like that is prohibited. Mm-hmm. That's what's in the appendix. And it's caused quite a bit of litigation because I think, when we're operating, I'm operating my own Facebook, which like you, I'm not on. I don't, but say I was, we can delete whoever we want. But once we become government actors and we engage in what's called state action, that's what the Supreme Court just ruled on last week, and they found that in that case, a city manager, you can be held liable at times depending on what you're deleting off of somebody. So that's what I've taken this appendix and tried, if it's passed by the board, that will guide our employees who are authorized users to try to protect and not get sued, in a nutshell.
All right. Well, I look forward to discussion of this on April 15, especially if there are any other questions. I will look through this and probably come up with some, especially reading through here, and I will learn about social media in between also.
Anytime, any questions, please call me anytime.
Thank you.
Thank you.
All right. Item 6.4. Overview of the February 2024 Neola update.
Thank you. As you can tell, this packet is pretty dense, so I am going to do my best to touch briefly on all of the policy updates. I don't plan on going through the administrative guidelines at this time, but we're happy to discuss those further if there's anything that this committee would like to discuss. So starting on page 2, there is policy 2623, student assessment and academic intervention services. This policy has been revised to include the requirement of House Bill 33 that by June 30th of each year, schools must provide parents with a student score on any state assessment administered to the student. The next policy is policy 2623.02, third grade reading guarantee, which has been updated to reflect the current administration windows for student assessments found in revised code 3313.608 and revised code 3313.0715. The next policy is policy 3120.04, employment of substitutes. This is a minor change to House Bill 33 that states that student teachers can be substitute teachers on a semester-to-semester basis upon approval from the board. The next policy is policy 3140, termination and resignation, which has also been revised to reflect changes in House Bill 33, permitting districts to provide notice to the board of the board's intention to terminate a employee by certified mail, regular mail, electronic mail with proof of delivery. The next policy is 4124, employment contract. This policy has also been revised to reflect changes in House Bill 33, permitting districts to provide notice of the board's intention not to reemploy a classified staff member by regular mail with a certificate of mailing, electronic mail with proof of delivery, etc. The next policy is 4140, termination and resignation. This policy has also been revised to reflect changes in House Bill 33, permitting districts to provide notice of the board's intention to terminate a classified staff member by, did I repeat one? I'm sorry. The next policy is 5310, health services, which has been revised to reflect revised code 3313.6413, which will allow students from grades 6 through 12 to have free menstrual products. The next policy is policy 8600, transportation, which creates additional options for the district to consider given the Ohio law limit as to how far students from grades K through 8 can walk, which is currently 2 miles. The next policy is 8600.04, bus driver certification, which adds a cross-reference to other relevant policies. Policy 8640 is also a transportation policy for non-routine trips, which has been updated for accuracy by Neola for the districts. The next policy is policy 8650, transportation by vehicles other than school buses. And this is with regard to non-routine vehicles and the requirements to drive those non-routine vehicles. And the last policy is 8660, incidental transportation of students by private vehicle. And this incorporates Ohio Administrative Code 33018319. And these are policies that our legal team will be going through and comparing with the APS current policies. And then based on this, we will make recommendations on what we prioritize as being best for the district to start with when we're reviewing everything.
Thank you. Yes, I noticed there's 12 policies and 8 guidelines here. Of these, do you anticipate having any that we should be on the lookout or we should discuss, and as a committee, how we'd like to bring these into roundtable? Would you want to present them like piecemeal into new business and then bring them to roundtable, or it's a lot?
Yeah, and I think that makes the most sense. I know that Ms. Falk will definitely have some input with regard to the numerous transportation policies that are included here. So we will rely on her and also the other departments wherever they're relevant to assist us in reviewing the policies and helping us to make recommendations moving forward. There aren't any massively glaring ones that I think that need to be dealt with immediately. But that being said, we'll have the rest of our legal team further review to make recommendations as to which ones we should be contemplating first as priority.
Are there any comments or questions? I have a couple of, where is it? Here we go. A couple of comments here. I know you said that our legal team and our administrative team are going to review these and prioritize them.
So the way I believe that this traditionally works is that I will work with our general counsel to determine which policies need to be updated, and then to the extent that it's necessary for other departments to get involved when policies will affect them, to make sure that logistically what we're doing is sound and isn't going to negatively affect or impact anything from a practical standpoint, then that's when we probably will rely on those departments more. But that will be kind of on a touch and go basis as far as what's into these policies when we actually start to delve deeply into them, because these are just summaries provided here in the Neola update.
I do have a question for the committee as this process continues. Do we only want to receive updates on the policies that will be changing, or if a policy is not being recommended, do we want to know what is not changing and why it's not changing? Does that matter?
Madam Chair, no, if the policy is not changing, then I don't really have a need to know why it's not changing. I would assume it's because it's working.
Okay, and then do we have a timeline of goal of when? Because I know we'll receive more Neola updates and more recommendations from Neola. So we have a timeline of when we'd like to have this complete by. Not complete, because I know that our discussion was one of those, and that was from October. But
I don't have a timeline to provide at this time, but if there's a timeline that this committee would like to set, we're certainly amenable to that.
when will we receive the next batch?
Thank you, Heidi.
So can,
Madam Chair, I would just ask, just for the public that may be listening, could you explain what Neola is? And to
Yes,
me.
so Neola is a company that assists school districts in forming policies. They make certain recommendations and help us to stay compliant with the local and federal laws.
yeah, the long and the short of it for the public is when other districts get sued, we find out and we learn from that and we adapt and we improve so it doesn't happen to us, so we can make sure we're doing the right thing for our students and our families. All right, so with the next large batch coming in August, I would like to pose a tentative goal to at least go through these and have a bulk of things done by August, and then possibly prioritize anything that might affect the handbooks. I know generally principals like to have their handbooks sent to the principals early, or not principals, printers early, and that kind of thing. So if it's not possible, it's not possible. If it's not practical, it's not practical, but it's always good to have a goal. Anything else on item 6.4, overview of 2024 Neola update? Yes.
Operationally, we are going to be looking at policies, and as we deem it appropriate, we will bring those policies to the policy committee. But that is something that we will be doing internally. So there are policies outside of these that we're also working on that will be brought to this policy committee. But operationally speaking, that will be done internally, and then we will bring it to the board for the board's review for the ones that we're working on right now.
All right. Anything else on item 6.04? All right, moving along, item 6.5, other policies to discuss. I know Madam Co-Chair has a policy to discuss, and it looks like since our agenda was posted, there's another one in here. It looks like 5120 is under other policies, and also bylaw 10651. So with that, I guess because it's in the agenda, we can start with 5120. I will note 6.5, it's written in here as a first reading. That is incorrect. This is not a first reading. It's in new business, but we can discuss as a committee if this is something that we would like to move into discussion item 4.4 on our April 15th meeting, like the other items from new business.
I can speak to 5120. So the reason that 5120 is included on the agenda is that there will be a special meeting, a public special meeting that was noticed by President Autry in the Treasurer's office for that really covers this exact policy as an emergency measure. So the redlined area that you'll see here is our changes made in order to assist the district in moving forward its redistricting and restructuring plan for 2024-2025 in a timely manner. And that way we can move forward with operational registration, busing, and technology needs relative to new attendance zones. So that everything can happen in a timely manner to best serve the district. So at that special meeting, just for clarification's sake, it would be a one vote change to this policy.
All right, and so committee, is this something that we would like to move to roundtable section 3 in our April 15th meeting?
So this, my understanding, we will be addressing this at the special board meeting. So I don't believe it needs to go to the round table on April 15th.
Yes. Yes, that's correct.
Are there any comments or questions?
Madam Chair, why is it before this committee if it doesn't need to come before this committee and can go directly to the special board meeting? Why is it here?
I did not put this on the agenda, so it can be whoever did that.
Yeah, I can comment. I thought it appropriate that policies at least come through the policy committee for the members to consider, but the nature of it being for a one-time reading approval kind of makes it not typical, but it still seemed appropriate to come through this committee before we address it Wednesday at the special meeting.
Yes, and I agree, President Autry. I think that the intention was just for clarification and make sure that we had as many opportunities as possible to notify the public and make sure that this is a policy that is going to be discussed on Wednesday, really for the sake of making sure that everyone's on the same page about this. And the more, you're totally correct that the better venue for discussing concerns about this policy would be Wednesday. But if there are brief concerns or anything that we wanted to discuss now, that would be fine too.
Madam Chair, so what I'm understanding is that this is an emergency clause.
That's
correct. What would be added to the legislation. So, I mean, if the bylaw says that you can add an emergency clause, and we've justified the terms by the bylaws that says that we can have a special meeting, and the special meeting was called by the president. So I don't have any more comments.
I would just say for reference, the bylaw is 0131 that lays out the parameters for an emergency to waive the 3 reads.
Yes, so I'm reading, thank you for that. 0131, we do have in our packets here, it says, when the board has reason to believe will close the schools or jeopardize the safety or welfare of the students or employees of the district. So I believe we're doing a first and final read because we believe that the safety and welfare of students and employees are in danger. Is that what is being said?
In order to ensure that the students that are going to be, the students and parents that are going to be affected by the redistricting and restructuring plan for the 2024-2025 school year, it is of critical importance that in a timely manner that the policy authorizes the board to change attendance areas in the district. The restrictions in this policy currently would hinder that, and it would put a large amount of strain on the school's ability to function operationally. They would have to get staff. The children need to know where they're going to school. Their parents need to know where they're going to be going to school, and that will all be affected by this policy, and that's the reason for the emergency measure. And I can add as well that the superintendent has reviewed this, as is outside counsel, and any other concerns I think probably would be more properly voiced in the special meeting on Wednesday.
Madam Chair, I would agree with that. So my question is, will the outside counsel who rendered the opinion be present at the special meeting?
It isn't someone from our office, but I can find that out. And is that something that the committee would feel more comfortable with?
Madam Chair, yes.
Yes, I would agree with that. And I'll leave it there. Yes.
Yes.
Yes, and thank you, Member Sykes. I would agree. This is not a discussion section of the committee. Bringing it to the committee would have been a decision that we would have made now if we wanted to move it to discussion. So this is not an opportunity for the discussion of this, but since it's here on our lap that it's going to occur without discussion, I guess we will discuss it on Wednesday on the emergency basis. I agree. I would like to concur with that formal request to have the person who came up with this present so that they would be able to answer questions specifically on the interpretation of jeopardizing the safety of students and employees and the process of skipping the committee. This is not a courtesy to present it to the committee. If this was a courtesy to present it to the committee, it would have gone through the committee. It would have gone into discussion like everything else in new business. This was just a line item. So I would also like to hear from the council present on Wednesday about changing a legal policy without involving the legal policy committee.
And I can just comment on that. Our office did also review this, and we agreed with the measure. So I don't want to put that on anyone else if that is a contention. It was reviewed by outside counsel and our counsel as well, but I think that there was another attorney working on it who did the initial edits. So I will speak with our legal team and that outside counsel and see if they will be present at the Wednesday meeting.
Yeah, I appreciate that it went through council, but it hasn't gone through the public. The committee is the public, and then the part of the policy here that's striked out is the part that involves the public. So that's what I would really like to hear explained why for that.
Madam Chair, and may I just add that, it's not unusual to have emergency language in a piece of legislation. And my wanting to hear from the legal counsel has nothing to do with my feeling whether or not I think that if we don't move with this redistricting, that it will not. I do believe it will cause some problems. I do believe that once we finally approve this, if we approve this, that there are so many things that this administration needs to do. And so I do not want to delay it. But at the same time, I also want the public to be as involved as possible with this. I want to understand from the legal counsel why this was not done in the first place. Why didn't we have the emergency language placed in the legislation when we met last time? That was my concern. I was concerned about a lot of things, the way that it was pulled off of the agenda, the whole bit, which I'll get to with my amendment. So I have no doubt that the superintendent and his staff have been working on this, that there are so many things to do. I know that families are concerned about what's going to happen, where their children are going, whether they can use the buses. There's all kinds of things. So the sooner we can get to this, the better. But at the same time, let's make sure that we follow the rules and regulations of this organization. And if, in fact, we could have prevented this by doing something last time, why not do it? If we could have included an emergency clause in the last piece of legislation and not pull it, why not do it? It is just not clear to me. It just seems... I really want to hear from the legal person that's been making making these opinions. I'm just, and quite frankly, I don't know why the legal person isn't here today. If you brought it before us to discuss, why that person isn't here today? Why that person wasn't in the meeting last week to explain why this was being pulled? But certainly, this person should be in Wednesday's meeting. And I'm amazed that the legal counsel that we are paying seem not to be able to show up to answer legal questions at the appropriate time.
I echo Member Sykes's many of those concerns, and I think what surprised me the most about the emergency language and why it's such an emergency is this item, as you referenced, was taken off of our board agenda twice. So the entire month of March, we had a meeting on the 26th and a meeting on the 11th. If this was an emergency, why wasn't it even on our agenda? It doesn't feel, we could have discussed it if it was an emergency. We could have mentioned it if it was an emergency. We could have had something for the community if it was an emergency. So I am surprised at this point in time to hear it's an emergency. Whether or not it is, I don't know. I'm just surprised it's an emergency after a month of being taken off the agenda. And I guess with that, Member Sykes, would you like to discuss your item 6.05, new business?
Thank you, Madam Chair. Thank you, Madam Chair. I appreciate it, and this will, as I said, this is because of our conversation that we had at our last formal board meeting, and that an item had been pulled off without what I thought was proper notification. And proper notification, again, this is not something that I blame the superintendent or the administration. It's just that when you look at 0165.1 regular meetings, it says generally the materials should be provided no later than 7 days prior to the meeting. That would be regular meeting materials. So it says nothing else. So for my thought processes, that means that everything should stay on the agenda that we receive 7 days prior to that. However, I can see how the administration, if there is a need to pull something, would pull it beyond the 7 days. So to clarify that, my recommendation would be to state under policy 0165.1 regular meetings, withdrawals or additions of agenda items shall be made no later than 2 days prior to the regular board meeting. And I just bring this to the committee to move forward for discussion. You know, committee members, board members may believe that it should be more or less than 2 days, or that we should continue to work under this language that we have here that is silent and does not speak at all to withdrawals or additions to board meetings, to board agendas or boards materials that we receive. But I would hope that we would provide something that speaks to when we should or should not withdraw or add items to the agenda, if nothing else for the clarification of the administration, so they would know if they're doing what the board expects, for the public, so they would know what they can expect. And for me, quite frankly, so once I review my agenda, I know if I have to keep checking back to find out if something has been pulled within the hours or so of the actual board meeting. So that's why I'm bringing it to start the discussion. And where this may end, I don't know. But at least I know we should have the discussion, because the inconvenience, especially when we deal with something as serious as redistricting, and as emotional as it is for our families, and as concerning as it is for our families, and as important as it is for this district. And when we come to a meeting and we have heard that we will be asked to vote on this item, but yet the item is nowhere on the agenda, which means that there is no conversation about it. That's the other thing. That's the insult, is that because you pull it off the agenda, then there's no reason to discuss it. So I imagine what our parents must be thinking. Well, where is it? Why didn't someone say something about it? So I felt it was my responsibility to at least ask, where is it? When was it pulled? Why isn't someone saying something about it? Because it's not just going to disappear. So here we are now saying that we're going to have a special meeting on Wednesday to deal with that. And if that was the case, then we should have known that. But at the very least, we should have had a better explanation as to why this item was pulled. I think that it is disrespectful to the public when we do these types of things. It is very disrespectful, because one of our bylaws says that we are to keep this communication going between this board and the community. And quite frankly, I am a public official, and I want the public to know what I am doing, that I understand this is their money, these are their children, this is their community, and I asked for this job. And I asked them to allow me to represent them, because I will keep them abreast as to what's happening in this school district. If something is pulled and I don't know it, then I can't tell them. And I am ashamed that I found myself in that situation at the last board meeting. And I am angry that I found myself in this last board meeting, not knowing that that item has been pulled from the agenda, because it was pulled at 1:45, and I finished reviewing everything at 9 o'clock that morning. So I don't want this situation to happen again. And I am not blaming the superintendent nor the administration of any. We are all responsible for making sure that the public knows what we are doing with their money, and especially with their children.
Thank you, Member Sykes. So with the committee, I see bylaw 10651. Do we feel this is ready for roundtable on our April 15th committee meeting?
Yes. I would agree, yes.
All right, thank you. I would also like to, in addition to this, make a request. If someone, I think once again, maybe if you could, or someone from one of the legal teams, to include in, I don't know if it's still this policy or if it would be other bylaws, but include for reference how notices work. I know sometimes I get emails that say, oh, special meeting, but then it's not in board docs yet, or sometimes we have the website and the website has a time. So if we could also include in this regular meetings, if it's not already, but include in this roundtable discussion how notice is posted, and whom and to when. I know in some of our trainings, our Robert's Rules of Order trainings, we had timelines of when it had to be, but I don't know.
Doesn't the Ohio Revised Code speak to like public meeting notices and when they're supposed to be?
It does. I don't have it in front of me right now.
So it should align with the Ohio Revised Code as far as meeting notices when public meetings are, and it's referenced usually when the notice comes out.
Yes, but in practice and implementation, when I receive that letter, do they receive that same letter at the same time? Like, who does that letter only go to us? Is it posted on the website at the exact same time? I agree, it should be, but is it?
Yeah, I would. Yeah, I can't. I guess I can't speak to that. I mean, I would hold because yeah. So all right, we'll leave that. Yes, add it to the agenda because it's a whole Ohio Revised Code as the public notice in public meetings. So that means the public. So
Yes. So I have on my notes now then, at our April 15th meeting, we will have 3 roundtables, item 2260, 7544, and bylaw 10651. I feel like that's a radio station. On our April 15th meeting. And we did not have a first reading of policy 5120 today, but it sounds like there is scheduled a first reading of that possibly on Wednesday. Are there any other items of new business? All right, with that 6:59 on time, we are adjourned.